Welcome back to Good Law, Bad Law. Today we're talking about a medical negligence case that a couple of lawyers in Montana handled recently that raises some pretty interesting medical ethics questions. My guests are Mike McKeon and Mark Kovacich, two lawyers who handled a case on behalf of a gentleman who had an advance directive when he went into the hospital, a DNR order. And when he collapsed and his heart stopped beating, that DNR was ignored and he was resuscitated. As he puts it, or as he put it before he died twice in the hospital before he finally passed away, with a lot of pain and suffering in between as a result. So we're in this crazy time of COVID where hospitals are packed. We're looking at rationing healthcare. We don't have enough vaccines for everybody, and there's, questions of who should get vaccine, which necessarily means that some people may die. Here's a case involving wrongful prolongation of life, but an also important set of questions about who has the right to make end-of-life decisions and how and when those decisions need to be respected. So a little bit different than what we've been talking about lately, a little change of pace from insurrection and treason, I know, but there's so many important issues to get to, and I thought this one would be one that everybody ought to be thinking about. And I hope you'll learn something and enjoy this episode of Good Law, Bad Law. Stay tuned. I want to welcome my guests, two lawyers from Montana, the great state of Montana, one of my favorite states. Michael McKeon, who practices in Butte, Montana, and Mark Kovacich out of Great Falls, Montana. Gentlemen, welcome and thank you for being on Good Law, Bad Law.
Thanks for having us.
Good morning, thank you.
I was really interested in a case I read about that you guys co-counseled successfully, and interested in it, particularly in this time that we're in, where there are so many ways in which our concept of what goes on in hospitals and important ethical decisions affecting medical care is really front and center on a lot of people's minds. And this case that you guys handled, which has been characterized as a wrongful prolongation of life case, seems to kind of run contrary to a lot of the other debates we're having in this country, where all of our focus right now in the midst of a pandemic is on saving life and battling this pandemic. So I really thought this was interesting to get into, and I'm looking forward to hearing more about it. Before we get into the case itself, guys, maybe you could start by telling us a little bit about yourselves, your background, how you, your practice, what kinds of cases you handle, and then we can get into some of the specifics of this case. Mike, do you want to go first?
Sure. I'm born and raised here in Butte, Montana. My father was a longtime personal injury attorney here, so grew up in the plaintiff's world, and went to Villanova out in your neck of the woods, and came back to Montana, the University of Montana, finished law school there, and returned to Butte to join with my father. During that time, we practiced for a few years, mainly personal injury, a lot of some products liability, he and his partner, and in the past few years, his health failed, and so I took over the firm. I had gone to law school with Mark's partner, Ben Snipes. He's a good friend of mine, and so we've worked on quite a few cases together. That's how we got on this. I got a call one day from Rodney, who my dad had represented back in 99, 2000, regarding his significant work comp claim.
I see.
Ultimately disabled him. Yeah. That ended his full-time job career and time as a ranch hand. But I got that call and did some research, thought we had something, and talked to Ben and Mark, and That's how we ended up taking this one on.
All right. And Rodney is the plaintiff who's the subject of the lawsuit we're going to talk about. We'll get into his story a little bit more. Mark, tell us a little bit about yourself and your background.
Sure. So I'm also born and raised in Montana. I'm fourth generation on both sides of my family. Did not escape for college like Mike did. I did all of my schooling here in Montana and have been practicing here in Great Falls for the last 20 years. Represent only plaintiffs in civil cases, primarily personal injury, but we have a little bit of a broad practice. I do a fair bit of asbestos work, and like we did in this case, we occasionally handle medical malpractice. Mike called my partner Ben about this case, and we went to Helena and met with Rodney and his wife, along with Mike, and decided to take the case for him. Okay.
So Mike, you were starting to tell us a little bit about Rodney Knoepfle, who's the gentleman who is the subject of this lawsuit and ultimately the trial. Tell us a little bit about him, and because I think that helps us understand the situation he found himself in toward the end of his life.
So, like I said, my dad had represented him over 20 years ago for a work comp claim where he had been, I believe, bucked off a horse and shattered one of his hips. So I had known of Rodney. I hadn't personally met him, but I think it was July 5th of 2016. I had come back from vacation and got a call, and it was Rodney, and he started to tell me his story. That he, back in March, he'd been hospitalized. At this point, I didn't know the significance and the amount of Rodney's prior medical condition. And he explained what had happened, and Rodney was pissed. Rodney was angry about what had happened at this point and didn't understand it. He explained to me, they had brought him back twice. He said to me, I died twice and they brought me back twice. And so, just a bare bones phone call, 5-10 minute call, I said, gosh, Rodney, I don't know if we have anything here. In my mind at that point, there was a recent decision in Montana that the summary judgment defense verdict in favor of the medical practitioner who had, it was a right to life, wrongful life case where a child was born after genetic testing that had failed. And the physician was ultimately given immunity. And that's where my mind initially went on this. I said, well, Rodney, give me a day or two to look into this. Started doing some research and came upon a great New York Times article about the right to die and DNRs. And that led me to the Alcia case down in Georgia. Still didn't know if we had anything where we were at. And the Alcia case, you may have read, was pretty similar. An older woman, she was in her 80s, had been intubated against her wishes. The difference there was that Georgia law actually granted immunity to physicians and healthcare facilities if they didn't follow a directive in good faith. I thought, we're in trouble. I don't think we have anything here. But knowing Montana's going farther back, Montana has one of the most liberal constitutions in the country, and knew that we had a right to life and right to dignity clause in our Constitution. Took a look at that, went to the statutes, and was amazed to find out Montana actually does the opposite of Georgia and a lot of other states, in that they grant immunity to physicians and healthcare providers for following the advanced directives. Criminal law, the failure to follow advanced directives. Once we got there, I thought it was unique. Thought there wasn't much like it in the country that had happened. Knew I was going to need to bring in some more power, and called Ben and Mark, and we went and met with Rodney, and really saw the devastation that this had caused he and his wife, and the suffering that he was
Well, so let me understand so far, and Mark, you can help fill in some of what we've covered so far. Usually, I think when people think of a medical malpractice or medical negligence case, a typical case you'd think of would be a wrongful death, where somebody's injured in some way and it causes their death. Here's a guy who has had medical issues up to this point, significant medical issues, and has an advance directive. And Mike referred to this as the DNR. Fill in some of the story on what those are and how those are used in medical care for what purpose.
Yeah, so I think one of the things that's important to understand is a little more about what led up to the decision for Rodney to choose DNR status whenever he was admitted in the hospital. So
and DNR means do not resuscitate.
Yes, do not resuscitate. Okay. And there are lots of other forms of advance directive that allow people to express their end of life wishes, what care they do want, what care they don't want. And those are generally recognized all over the country. And there's not much controversy over a person's choice to make those kinds of decisions. What was a little more difficult and challenging in this case is what are the legal consequences for healthcare providers when they fail to follow those things. Mm-hmm. So for Rodney, he had profound orthopedic problems from the time he was a very young man. He had multiple back surgeries. He had a hip replacement or two, I think, and complications with all of those things where he had been dealing with chronic pain for years.
Blind in one eye from a stroke, paralysis secondary to that stroke. The globe summed it up.
Started to have heart problems, where I think he'd had a heart surgery previously, and every day he would wake up to a bucket of pills that he had to take, and just really was not having great quality of life. And so when the time came to talk about what do you want in terms of medical care, if you're struggling with, if you're admitted in the hospital and something happens to where, the life support could bring you back or treatment could bring you back, do you want us to do that? And he was very clear that he did not. And he had given his wife power to make healthcare decisions for him, made it very clear to her that he didn't want CPR or any kind of life-sustaining care if things declined, and he would otherwise pass naturally.
So it's interesting that, Mike, you said that Montana has a liberal constitution, and from my experience, when you say that, I think that means, tell me if I'm right, it's liberal in the sense that it places a high value on the individual's rights. And yes, is that what that means?
100%.
Right.
Montana's an independence.
Right. So we value the individual's right to self-determination, to make decisions for him or herself. And an advance directive or a do not resuscitate is a way that while you still can make decisions for yourself, you make decisions, you put it down on paper, you let your doctors know ahead of time, hey, if something goes bad or I'm getting a situation, I choose, it's my choice, it's my decision, how I want things to go and how I don't want things to go. And so Montana really is from what you're explaining, Montana places a high value on that.
That's exactly right. And that's the Montana way of life. Right? Mm-hmm. In all aspects, and most certainly in your health care. Yes.
So Mark, so what happens then in the story? So with that medical history and taking a lot of pills, and I take it he couldn't work any longer. He's in his late 60s and he ends up in the hospital. Mike explained that he died twice. What does that mean? Well, what actually happened to him when he was in the hospital?
So he was admitted to the hospital. They put him in a room. His wife took great care of him. You know, she helped him with all of his healthcare challenges, was typically always there, but she was working. And so when he was admitted to the hospital, she was there for most of the time, but she had to leave and go to work. And so he got up to use his restroom in his room. He was able to ambulate himself to the restroom, and he collapsed in there. And his heart stopped. A nurse found him, called for help, and she called a code which signals to the people in the hospital that the code team needs to come and they're going to perform CPR. And it was a mistake for her to do that because he was a DNR patient. He had a wristband on designating that he was a DNR patient. His chart indicated as much. And I think it was not, I don't believe it was an intentional act where they recognized Rodney's a DNR patient. We don't care. We're going to resuscitate him anyway. It was a lack of training and a lack of awareness by the people who were there at the time.
I see.
And they rushed in, they performed CPR, and they brought him back. And as soon as he had enough awareness after having come back to understand what had happened, when they told him what had happened, he was incredibly upset. And he made that very clear to everyone. And by then, his wife was back to the hospital. She, by the way, got a phone call during all of this and confirmed on the phone call that Rodney did not want CPR, that he was a do not resuscitate patient. And by the time the nurse who talked to Rodney's wife, Cheryl, and confirmed that information came back to the room, it was too late, so to speak, because Rodney's heart was beating and he was back.
You know, I've over the years, I've handled a lot of cases involving codes and resuscitations and emergency intubations in all kinds of different situations. So I know, but I think probably a lot of people don't realize that when you are resuscitated in an emergency situation like this, in a code where your heart has stopped, it's not like the doctors just wave a wand and you're fine. It's a very traumatic, most often, I think it's a very traumatic process. They're CPR, they're pounding on your chest, they're pumping you full of drugs emergently. They may have to intubate you, which means passing a tube down your breathing, your airway. And often people end up physically very traumatized because of the resuscitation.
It's interesting, Aaron, that you mentioned that, because the hospital and the doctor denied negligence throughout the case, but they admitted that they should not have, that it was a mistake to resuscitate him. I never quite understood what their position was there, because they admit we shouldn't have done this. It was a mistake, but we weren't negligent. They denied the breach of the standard of care. They did, however, from the get-go, agree that they should compensate him for the physical harm from CPR to his chest. He had bruising and in pain in his chest from, I think the record indicated more than 10 minutes of chest compressions. And they were happy. They would not agree that that by saving his life and prolonging his life, that constituted harm to him and damages that should be recognized under the law. But they were willing to pay for hurting his chest, performing CPR without permission.
Well, that's a very interesting point, and I can see how that could present a challenge for how you have to try this case. And Mike, I'd like you to speak to this. The case did go to trial and resulted in a plaintiff's verdict, and a successful verdict. As I understand it, a $400,000 verdict, which to my ear sounds like compensation for a lot more than a bruised chest during CPR. So how did you present damages? How do you try to put to a jury the issue of violating his right not to have been resuscitated into language that a jury then can use to award damages in monetary terms?
You know, I think as far as putting that to the jury, we have to give a lot of credit to Rodney's wife, Cheryl, who was able to tell the story to the jury of Rodney's suffering after the resuscitation effort. After it occurred in 2016, he survived another 2 years. Within the first year after the resuscitation efforts, he was back in the hospital 3 times. And sent down to Salt Lake to his cardiac specialist, included in there. Cheryl lived this. Her life was taking care of Rodney and watching him having to suffer each and every day. And putting Cheryl on, she touched the jury, and she was able to tell the story of how everything had changed. You know, Mark had talked about how she had been working at the time Rodney was hospitalized and resuscitated. Well, in fact, Rodney had been working not a month and a half before as a bus aide still, just part-time. He was able to get out, and after that, he was relegated to a 50-foot hose that stuck in here. And that,
what does that mean, a 50-foot hose?
Oh, oxygen. He was on an oxygen leash, essentially, and couldn't leave without it, which he hadn't had before. So that's
the big part of what we did was communicate that the reasons why he chose the do not resuscitate status and the advanced directive that he had in place with his wife, and then linked that to what happened after these events to show that he suffered exactly what he intended to avoid by making those decisions. And then the other aspect of it was we really focused on the effect of jury verdicts in deterring conduct, and tried to frame the case in a way that allowed the jury to understand that it was important to recognize what had happened here in the form of a verdict to prevent this from happening again, and to give healthcare providers something to think about, to be more respectful of those kinds of decisions by their patients.
Well, that's a good segue, Mark, because you know I teed this up as raising ethical questions, and so I'm curious what you think, reflecting back on the experience, and maybe you talk to some of the jurors afterwards. I don't know. I'd be interested to know what they thought about what they were doing, which was awarding a verdict here for Rodney's family, and if they were looking forward to how this could impact other cases and just awareness generally. You know, again, in my own experience, I find people often avoid thinking about end of life decisions because it's uncomfortable, because we don't like to think about dying. We don't like to think about making plans, even because in some way maybe we're tempting fate. But for those who do, and as a lawyer, I always recommend that people do, because of exactly what we were talking about earlier. If you don't plan ahead, you're leaving it to someone else to make those decisions for you. Their end of life decisions are going to come up, and it's really a question of, are you going to put yourself in a position to influence those decisions or leave them entirely to someone else? So how much of a I guess in my rambling way, I'm getting to asking, how important do you think that was in how the jury worked its way through the issue? This idea that an individual's right to make end-of-life decisions like this ought to be respected, and however the mistake happened, it happened, and those rights weren't respected.
That was the whole case. Yeah. And we did talk to the jurors afterwards and got pretty consistent feedback from them that they didn't want this to happen to other people. And they understood that it was important that there be some recognition of the failure of the hospital and the nurses and the doctor to do what they were supposed to do and respect Rodney's wishes. Have systems in place that allowed them to respect his wishes. Mm-hmm. And their verdict, in their mind, was important to discourage healthcare providers from making those same mistakes. And we argued the case that way, and I think that was an important part of it, and part of the reason that it was a successful outcome.
Well, I'm curious what you guys think too, from a patient point of view, lessons learned from this case and, from this experience, because I first heard about your case reading about it in a newspaper for physicians, and they, comment on cases oftentimes. That's where I heard about it. And the physician who was writing about the experience of your case was talking about how this kind of problem, that is, someone who has an advance directive, has a DNR, how there could be a miscommunication within a hospital when you most need to have awareness of that advance directive, particularly in an era where we have electronic medical records. So you could have a situation where a DNR is in the paper record for the patient, but somehow isn't in the electronic medical record, and there are all sorts of problems that electronic medical records were meant to solve, like prescription errors, but in doing that, other problems have been created. But I'm curious in this case, because in this case, the hospital actually had a wristband system. So it wasn't depending on the doctors and nurses and techs and everyone being aware of the DNR order, trying to find that in a record. They had a wristband system. It's just that it wasn't followed in this case. What do you think, from a patient's perspective, people ought to do to make sure that if they have exercised their right to make end-of-life decisions with a DNR or an advance directive, that they take steps to make sure that's carried out?
One additional step above the DNR that we come across, and Rodney did have one of these as well, though it wasn't as documented, but is the physician's order on life-saving treatment. And that, the P.O.L.S.T is how it's referred to. And when you're in a terminal condition such as Rodney, what that means is you can go to your doctor, have the conversation, the tough conversation, but as you said, it's an inevitable, death is coming to us all. It's an inevitable action, but it's a conversation that needs to be had. And when you and your doctor, your physician, come to the conclusion that that's an appropriate form for you, the P.O.L.S.T is filled out, and in Montana, I don't know how it works in other states, it goes into a database. And it also is, you put it on your fridge. It is documented everywhere.
And what is it called again, Mike?
It's a P.O.L.S.T, Physician Order on Life-Saving sustaining treatment.
P.O.L.S.T.
And-
P.O.L.S.T. Gotcha.
And it's a database for at least the state of Montana as to what your treatment wishes. I think going forward for people that, are thinking and getting there, we're, an aging population, especially in Montana, but a lot of the baby boomers are coming along to that age. It's a question of making sure you're documenting your wishes with as many people as you possibly can. Because you can't just rely, even though we hope we should be able to, you've got to make sure you're actively pushing your wishes.
Yeah, and I mean, I think in a time of COVID, it's all the more important. I mean, we're, of course, every life is valued by the person and their families, but I'm thinking, I mean, we have 400,000 people dead. The numbers are not going to slow down, at least in the near term. And, for people who are hospitalized and get this disease severely, many of them end up on a ventilator. That's no picnic for a lot of people. It can be life-saving, but can also leave all kinds of lasting damage. I think it's at least a question, it's at least a conversation that a family might want to have, either for themselves or, for people our age, thinking about our parents. If something should happen to one of our parents or an uncle or grandparent, what have you. And for states that don't have this system where it would appear I take it statewide, in whether you go into a doctor's office, whether you go into the ER, it should show up if you're in this database, right? So
I would say it's important for people who have made that decision that they don't want life-sustaining or life prolonging care, not to take it for granted that the healthcare providers are going to know from the system. Be proactive, communicate it, make sure that the people you're entrusting your care to really do understand what you want. One of the interesting things that happened in our case is we learned that there had been a change in the color system for the wristbands. Actually happened after the incidents with Rodney, but there's an effort among some hospitals to be more uniform with which colors they use for things like do not resuscitate, or if a patient is a fall risk, or maybe they have a latex allergy.
Right.
Most hospitals use wristbands as an easy way to communicate to the people who are caring for a patient important things about that patient that they may need to know, such as do they have a do not resuscitate order? And the hospital in Helena was using, I think maybe it was a blue wristband at the time that Rodney was admitted, but they're in this effort to get more uniform, I think it's purple. And so they had switched to purple, where if you have a nurse who comes from Utah working in your hospital and she's new, and if your training's not what it should be, maybe she doesn't know what the blue wristband means.
That's a really good point.
Another thing, in addition with the P.O.L.S.T, and speaking to P.O.L.S.T comes into effect a lot more frequently with EMTs when someone's it goes down at home. And EMTs are trained, and in the P.O.L.S.T, you're directed to keep it on your fridge. And EMTs are trained to look on the fridge for those types of directives.
Gotcha. Oh, that's fascinating. Well, this is great. First, congratulations on the verdict on really fascinating case. As a plaintiff's lawyer, I know it often takes courage and the tolerance for risk to take on a case that doesn't have all the legal pieces already, laid out for you. So to take something like this and sort of test broader principles in the law and in the Montana Constitution, I know took some daring. So, congratulations on that. And I think it stands to reason that this will have a positive impact certainly within Montana. And I hope maybe if we bring some attention to it, people become more aware of this issue, outside of Montana. That's my hope. So great job on the case. And thank you guys both so much for being on Good Law, Bad Law to talk about it.
Thank you, Aaron.
Thanks, Aaron.